She did tell Miss Apple that. I'm aware.
Probably didn't put it that way, but you know what I mean.
Yes.
I don't know, I get hurt. She wouldn't stay around. I wouldn't have either, I guess. Bench warrant will issue for defendant's failure to appear. No bond.
Thank you.
That warrant will issue immediately. Court does call the case of People versus Chiquise Skelly.
We're ready.
Trevor Maybell for the people, Your Honor.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Gully. Mr. Gully, please state your name for the record.
Chiquise Gully. Thank you.
Your Honor, I've had a chance to speak with the prosecution about this matter. They provided us, was today or late yesterday?
This morning.
This morning. With further information, they plan to amend the charge here. Based on that, we're asking for an adjournment of the preliminary examination to be able to go over that information. Also, Mr. Gully.
They're going to amend?
Yes, they're going to amend the.
Your Honor, it was at the end of the day yesterday that we received a lab report from the toxicology department and the methods, I believe, that tested contraband pulled out of the defendant's vehicle allegedly. And we do seek to amend. I made an offer related to not adding that count in exchange for a waiver. We thought that the charges that are currently brought could potentially stand given the defendant's current status on parole. But Mr. Brown's response was that Mr. Gully intended to file or to retain private counsel. So I don't think those conversations went very far. But I was going to give new counsel an opportunity with that offer prior to filing the amended complaint.
Well, if I adjourn this out, I'd be adjourning it to a, 21st?
Yes, we understood that to be the date, Your Honor, and I think that's fine for all the.
Right, but if there's going to be an amended complaint and it's set for preliminary examinations, the gentleman's entitled to go to a preliminary examination on those charges. So,
PCC.
Pardon? Well, I'm not going to send it back to a PCC. I mean, if they're going to be amended charges, let's do his exam.
Okay.
Right, but what I don't want is a circumstance where I'm coming up on the 20th. He gets new counsel, or they're there, or they're considering the offer, and then all of a sudden I get this amended complaint, and I'm going through this again because he's entitled to have his exam.
Right.
So
That's fair, Your Honor. The people will file the amended complaint if we choose to do so within 7 days of today's date.
Preliminary examination, then will be adjourned.
Thank you very much, Your Honor.
I'll adjourn it to October 21st, 2025.
Okay.
9 a.m. That is before we can. 21st.
Yeah.
Bond will continue. Thank you. Mr. Mackey doing? Court does call the case of the People versus Ahmed Ajibori.
Ask him the people.
Good morning, Your Honor. You and your staff, Brian Berry, appearing on behalf of Ahmed Al-Jabori. State your name.
Ahmed Al-Jabori.
He's waiving.
Yes, Your Honor. I've explained to him his right to have a statutory right to have a preliminary examination. He wishes to waive it.
And you understand that that proceeding is where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you won't have that hearing and you'll move to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on the same account.
As to the information, Your Honor, will waive reading and stand mute.
Defendant every way formal reading standing mute. Court will enter not guilty plea. Pretrial will be set for
November 24th at 1:30 with Judge Hooven.
November 24th, 2025, 1:30 Judge moved. Bond will continue.
Thank you, Your Honor.
Thank you. Get this out for Chavalus. He's been creeping. Oh. Court does call the case People versus Moses Steger.
Trevor Maybell for the people, Your Honor.
Where are my rubber bands down?
Good afternoon, I'm Rob J. Kilwell on behalf of Moses Steger. Judge, I would say just for the record, we worked out, we're going to waive up to circuit court, but based on that waiver, some charges are going to be dismissed, including one that will be forthcoming from the public defender's office. Mr. Lauren Brown talked to this young man and he's agreeable to, if we were going to waive up to circuit court, that R&O will be dismissed. If you understand. Doug?
Well, I know. I didn't. I was with you until the RNO is going to be dismissed.
Your Honor, we're here for two cases today for which Mr. Kilwell represents Mr. Staker on both files. Defendant does have a third file, 25 FB 1274, which the PD's office retains, is still representing Mr. Staker on that. Both the RNO that's set for today in 25 F2 1193 and the public defender's RNO case, which is not set for today, which is coming up in a week for PCC, Your Honor. That's 25 FB 1274. As part of the waiver, both RNO files, only one of which is set for today, is being dismissed.
Okay. So what's being dismissed?
Count 2, the felony firearm.
You're going to do that all in circuit, though.
No, as part of our waiver agreement to waive up to circuit court, the prosecutor has agreed on case 25 F2
To dismiss count 2.
count 2. And then my 25 F2 1193 RNO, that's going to be dismissed. And then another RNO with a PD has, and they've spoken with him and he's agreement to dismiss that one. Our agreement to waive up to circuit court.
Right. So let's do it this way so that we're all clear. The case ending in 1193 is going to be dismissed.
Correct.
The other case that's out there is also going to be dismissed.
Correct.
Right?
Yeah, that's
And then he's waiving in the case 1351 on counts 1 and 3.
correct.
Okay.
That would be better.
Why
way to say it.
did that not get said that way?
Judge, I was gonna say it that way, but the prosecutor said go. the
Well,
other
no,
way.
you know
Just
what?
kidding.
So when Kilowalt started, he was talking and I got to the end and I didn't understand, but that's my relationship with Kilowalt. I didn't know what he was talking about.
That's true.
So then I thought, well, you're going to give a shot at it. Okay, I get, you're going to tell me, and you just made it worse.
A little closer.
Well, no, it really wasn't.
Judge, you saw right through us, Judge, you know, you being the
All right.
intelligent, caring judge you are.
Sir, did you understand all of that?
Yeah, I understand.
I explained to Judge, we went over the waiver. He knows he has a right to have an exam. Is that right, Moses?
Yes.
And
All
at
right.
this time, we're gonna waive it to circuit. Hopefully we can work.
You're
this-
waiving to circuit court on counts 1
1,
and 3 in one of the cases. And
Correct.
The case that's up today is going to be dismissed. The other one up next week is going to be dismissed. You understand that, sir? All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 3 with count 2 in being dismissed in case 1351. Mr.
An R&O case also is being dismissed, 25 F2 1193. It's up today.
I know we said that 50 billion times.
Okay.
Now, I just need you to do the arraignment on this one.
Okay, fine. I acknowledge you received the information. We waive its reading. My client would stand mute.
Defendant having waived for a reading standing mute count was 1 and 3 in 1351. Court will enter a not guilty plea. Pre-trial on that matter will be set for
October 21st at 1:30, Judge Conklin.
October 21st, 2025, 1:30 before Judge Conkey. The bond on that matter will continue, and then on case ending in 1193 up to date, that matter is dismissed as part of this agreement by Nally Cross. All right.
Thank you, Judge.
Thank you.
Right, I'll come see you, okay.
Take the scenic route on that one. Court does call the case of the people versus Syntasia Callaway.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Rob. On behalf of Ms. Callaway.
Hello. What's your name, ma'am?
Natasha Calloway.
And Your Honor, today's the date time set for preliminary examination. At this time, people are unable to proceed as to counts 1 and 3 and would ask the court to remand to district court on count 2.
People being unable to proceed as to counts 1 and 3, those matters are dismissed. Continue the not guilty plea as to count 2. I'll set a pretrial on that matter for
October 16th at 9 a.m.
Judge,
October.
I'm not available that week. I'm sorry. Can we do it
I don't have another day for Judge Washington.
Okay, I'll square it up. October 16th?
October 16th, what time? 10 a.m.
Yeah, 9.
October 16th, 2025, 9 a.m. before Judge Washington.
Judge, may we approach very briefly on the tether issue?
Yes, you may.
Thank you. Judge, thank you for the bench conference. Again, I stated my case to you, and you being the considerate judge you are, I wish you would act on it.
Is there anything from the people?
Your Honor, I've let the court know our side of this up at the bench, but I can reiterate that we would object to any modification of arguing the facts of the case.
And I understand the facts of the case. I also understand that at this point there are 2 felony charges which he's unable to proceed on. The defendant has posted a substantial bond in this case and would have a great deal of risk should she decide to take off. Taking all of that into account, defendant may be removed from the GPS tether.
Thank you, Your Honor. Okay.
Yeah, ma'am, I'm going to let Judge Washington know, so you better show up and follow everything. You hear me?
Oh, I will.
Thank you.
Thank you.
Judge.
Court calls case of the people versus Andrew Harrison.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Davi Lebo on behalf of Mr. Harrison, who stands to my right. Mr. Harrison, could you please tell the court your name?
Andrew Harrison. All right.
And Your Honor, today's the date and time set for preliminary examination. At this time, people are unable to proceed as to count 1 and would ask that counts 2, 3, and 4 be remanded to district court for the proceedings.
3 and 4. Count 1, in this case, people being unable to proceed is dismissed. I'll continue to defend it's not guilty plea as to counts 2, 3, and 4. Set a pretrial date, 15th, what date? October 29th, 2025, 10:30?
Yes.
10:30 before Judge Perry.
Thank you, Your Honor. My client would like to inquire of the court if, in the inability of the people to proceed, if the court would reconsider Mr. Harrison's bond.
Given the circumstance of the case, and particularly the allegations, as I understand, under count 4 now.
Thank you, Your Honor.
Bond will be to court. Court does call the case people versus Jessica Hafner.
Alberto, on behalf of Ms. Hafner, who's approaching the podium and will be standing to my right. Once Mr. Killaway clears the path.
I'm sorry.
Jessica, please state your name for the record.
You purposely got in her way, Killaway. Go ahead.
Your Honor.
Your
Thank you,
Honor, may we approach briefly?
Ah, boy. Okay, yes.
I just
I will grant an adjournment of the preliminary examination in this matter. It will be adjourned to October 21st, 2025, 9 a.m. That's before me. Ms. Hefner, I'm going to, without going into a lot of detail regarding it, I'm just going to give you the admonition that you are not to have any contact whatsoever with these children. You understand
I
that?
understand.
Pardon?
I understand, Your Honor.
And so if it is determined that you have, or the allegation is people are going to file a motion, they're going to bring it before the court. And if I make the finding that you've been in violation of bond in this case, I think Mr. Burdell will tell you, I will only have one option, but to remand you.
Yes,
I
sir.
don't want to do that. I'm going to give you the warning today. And so you can, whatever you do, you can't say I didn't know. Understood?
Yes, Your Honor.
This time her bond power will continue. Thank you.
Thank you, Judge.
Where are you going? You're like leaving? You were here all day. Stop just
I know.
messing up my whole docket. Now you're gonna just walk out. All
I
right.
was keeping it going. I am.
Yeah, that's what it is. It was you. All right. Take care. Have a good day. Here we are. Court calls the case People versus Annie Oglesby.
Trevor Maybell for the people.
Good afternoon, Your Honor. Tina Sachs on behalf of Ms. Oglesby.
Yeah. Your name, ma'am?
Annie Oglesby.
What are we doing? She's got a plea form in that one. And
Put this one in writing, Judge, so I wouldn't have to articulate.
oh, good. All right. So
Speaking of something.
I got you. Okay. So I have a plea form in front of me that indicates that the defendant would be pleading guilty to the charge of operating while intoxicated, the 93-day offense. Upon a successful plea to that charge, count one in that case would be dismissed, and also case 25F5 5753, which is also up today.
Correct, Your Honor.
All right, correct. That's the court's full understanding of
Sorry, I didn't hear you.
which part. I'm just asking you, that's the court's full understanding of the agreement. Is that correct?
It is correct.
All right. May I have her sworn?
Right. You solemnly swear in affirm the testimony about to give, who's the whole truth and nothing but the truth, yeah.
Yes. Annie Marie Oglesby.
This is court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor. It is punishable by 93 days in jail, up to a $500 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
All right. And understanding all of that, do you still wish to plead guilty?
Yes.
I should also apprise you of one other thing, and that is that while I'm taking a plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. And to that charge, how do you plead, ma'am?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form. Is that correct? Or had counsel sign one on your behalf?
Yes, sir.
Any questions regarding those rights?
No.
On the podium, you'll see it. Please look at paragraph 5. Those are your rights. If you're part of a trial, you're pleading guilty to giving up those rights as well as all the rights on that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
October 11th, 2024, US 23 near Gettys Road, Ann Arbor Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor? Well,
No.
no, you had ingested a controlled substance,
Yes,
correct? What had you ingested?
methamphetamines.
All right. Were you stopped by the police?
No.
Was there an accident?
Yes.
What happened?
My car flipped 5 times and
You lost control.
yes,
And the vehicle flipped.
yes,
And so did the police and hospital personnel or medical personnel arrive?
as far as I know, yes.
Okay,
I was unconscious.
got it. But you do recall driving the car?
Yes.
At least the initial portion of the accident,
Yes, sir.
as well as your ingestion of the controlled substance. You recall that?
Yes.
Okay. And so at the hospital, would you dispute that there was a blood draw?
Your Honor, she was unconscious.
I was in a coma for a week and I was on life support.
I asked it the way I asked because of what she had said about not being aware of certain things. So I get that, but are you disputing that once you were taken to the hospital, that they gave you a blood draw?
No.
All right. And was it reported to you that the results of that blood draw showed the presence of methamphetamine?
When I woke up, yes.
Okay. And you saw those results?
No, I didn't see them.
Well,
Oh, yeah, my lawyer showed them to me.
Oh.
Sorry.
do you have any reason to dispute those blood test results?
No.
given all of the circumstances?
No.
All right. Ma'am, if I accept your plea, I need you to understand that if between the time of my acceptance of your plea and the time of your sentencing, you commit misconduct as defined by the Michigan court rules, you would not be permitted to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and reporters ordered at 1482 probation. Sentencing of this matter will be October 14th, 2025, 10 a.m.
Yes.
10 a.m.
Your Honor,
before Judge Barr. Yes.
you only said dismissal on one case.
Yes. And case 25 F5 5753 is dismissed also.
Thank you.
Your Honor, I'd like to make a bond argument.
Yes.
Ms. Oglesby has been incarcerated for 32 consecutive days, I believe. Now, with the revocation of the bond by you, I am renewing my request for a bond modification. And Mark, Ms. Oglesby has also secured employment, and I spoke with her employer, who is present here in the back, Mark Aronoff. And again, she would be staying in Pittsfield Township and has secured transportation for testing with her mother, who she will also be staying with, and her employer is also assisting her. And I think that given these conditions and the sentence or the plea that was just entered, it would be reasonable to reinstate her personal bond and release her.
With the testing required.
With the testing requirement, yes.
Any response from the people?
Your Honor, I'm certainly inclined to agree. I think that that's appropriate. I just, I'm a little unfamiliar about the circumstances that has defendant in custody today. I think she was previously ordered to test, and it was her failure to do so that led to her being asked. So I'm
But the condition was different. She was living in Jackson and she did not have money. She had just gotten out of jail. Now she's secured employment and
Well,
post.
I've heard that part of the argument, which is.
I was stating it for him.
That part of the argument, which is why she's still in custody.
I'm not opposing the request, Your Honor, and will defer to the court.
I'm gonna just need all the forms and everything redone with their testing requirement. What I'm gonna do is I'm gonna grant the request for change in bond. I'll reset her bond, $5,000 personal recognizance bond. You will have the testing requirements, so once you are released, you need to get yourself over to community corrections, do the intake.
Today, yes.
All right. And I would further indicate to you, ma'am, that I certainly would be I would communicate to Judge Barr that should you fail to go through with that, or should you test positive at all, that he should revoke your bond.
That's not going to happen, Your
Because
Honor.
what that means is that you're lucky to be alive, and I think you know that.
Yes.
And so Ms. Saxon asking the court for this ministry is showing that to you. If you mess this up, that means you don't care. And at that point, neither should we. Understood?
Yes, Your Honor.
Thank you.
Your Honor, may I please have the date, the sentencing date? I'm sorry.
Sentencing date is October 14th, 2025, 10 a.m.
Thank you, sir.
Thank you.
Thank you, Your Honor.
In Judge Simpson's courtroom, one rule always stands. Actions speak louder than apologies. Today's case made that clearer than ever. A young woman stood before the judge-com on the outside, shaken on the inside. After repeated probation violations, missed screenings, and ignored warnings, she still hoped she could talk her way out of the consequences. But Judge Simpson doesn't fall for excuses. He's patient, not blind. You've been given every opportunity to turn your life around, he told her. At some point, words stop meaning anything if your actions never change. That hit harder than the sentence itself. Everyone could feel the truth. This wasn't about punishment, but responsibility. The system had tried to help her again and again, and she chose not to listen as the bailiff escorted her out. You could see the realization settle in. Oh, those chances wasted. That's why so many people watch Judge Simpson's courtroom. It's real. It's honest. You can't lie or cry your way out of consequences. It reminds us that redemption isn't something you say, it's something you live. So ask yourself, if you stood before Judge Simpson today, would you need to speak at all? Or would your actions speak for you?